Okay, for today's lesson, we're going to talk about the exclusive right to sell listing agreement.
Yay!
Yay! Now, this is for several different audiences here. If you're in pre-license and post-license, we'll try to allude to some of the things that come up on the test. And then, of course, for those of you that are in the field, these forms change every year. So this is just an update to let you know what's going on with the new form. So let me start over from scratch. Exclusive right to sell listing agreement. A little bit later, we will talk to you about why this makes it different, and it is by far the most common listing agreement that you will use when working with a seller. And Kandyce, let me go one more sentence here, and then I'm going to let you jump in and add what you think is important here. Notice that as it leads off into this form, it introduces the party to the form. So one of the most important things about this form, one of the most important aspects of this form is just simply who the contract is between. And if it's a listing agreement, it is between the seller and the firm. Now, I know you're the agent that's going to do the work, and you're going to be the one that's going to be the procuring cost of this. But technically, all agency agreements are between the client and the firm. As we talked about in the offer to purchase class, be very clear about the sellers. Do you have all of the sellers, and can you get all of their signatures as you are entering into this listing agreement?
No, I think you just covered everything. That's exactly what I would have pointed out. It's the exclusive right to sell listing, and we know there's going to be a test questions. So if you want to know, you got to keep listening. And the fact that it's just between the seller and the firm, not the seller and you, the agent. The seller did not hire you. They hired the firm. You leave the firm, you may not be taking your listing with you.
Great point.
Now let's get to this note, right? Because this note is really, you had mentioned it in the offer to purchase class, and we're talking about when somebody dies or you have an estate, and what is it that people really need to know?
Now, in regards to this form, I go back to the comment I made just a moment ago. You need the signatures of all of your sellers. And what this note does is it talks about the idea of if it is an estate, make sure that you're talking to the attorney to clarify whose signatures you need. I had a transaction last week that was difficult because we needed not only the heirs, we also needed the spouse of the heirs. We also needed the executor administrator for the estate. So instead of needing 2 signatures, we needed 5 signatures. Similarly, if you're dealing with a trust, a limited liability company, a corporation, etc., you need to make sure that you're dealing with the party that has the authority to sell the property and also to sign for the agreements.
Which really just comes down to, as we always say, you need to consult an attorney, right? Because there's just so many things that can come up. Yes, you have some basic real estate knowledge, but nothing where you can give legal advice because you're not trying to go to real estate jail.
I'll say 2 things, one for test purpose and one for reality.
Okay.
For test purposes, if one of the answers is consult an attorney, you know what? That's probably good advice to take that particular answer. And then also in the field, a lot of agents sometimes are wary about reaching out to an attorney. Do not be. The brokers in charge were put on this earth to help you. The attorneys that you deal with will be glad to help you because it saves them trouble in the long run if they address it up front.
Exactly. Just ask. It's always better to ask. All right. So our next section is going to be the part that is bolded here. And we see it's talking about the working with real estate agents. We're just confirming that that seller has received a copy of the Working with Real Estate Agents and that you reviewed it with them. Remember, it is not good enough just to give the Working with Real Estate Agents. You must review it.
Clearly, test question alert right there.
And next, our first section 1 is term of the agreement. What does that mean?
There is a rule for agency agreements by the Real Estate Commission, and part of that rule says all agency agreements must have a start date and an end date. So when we're talking about the term of agreement, this is where we talk about when it starts and when it ends. Why is that in there? Because it's required to be in there by Real Estate Commission rule, and that's what this paragraph allows you to do.
Exactly. Now, the term, as you see here in A, it's going to start on its effective date and shall end at 11:59 on its expiration date. But we have that effective date again, and it's in caps. And why is it important that it's in caps?
Well, again, let me remind you of the concept of defined terms. Every time we see this, at some point in the contract. You've already seen it in the previous sentence that they use capital E, capital D effective date. So this is a defined term. We're getting ready to define it right now.
Mm-hmm. And our effective date is either going to be the date that this is signed by both the seller and the firm, or if this is a property that's already listed by another real estate firm, this is saying that this won't start. This agreement won't start until that one ends. And that expiration is, wrong line there. We go back. That expiration is going to be noted right there.
Yeah, just real quickly on this, because it's not testable, but it is important in the field. I often get questions from my agents. Hey, listen, the seller is not happy with the person they have. When can I talk to them about the property? Technically speaking, an agent can respond to a seller who asks about his services, but notice, as Kandyce said, you cannot start working for a seller who is under contract with another agent. And you cannot solicit that person. You can only respond if they try to solicit you.
Exactly. No real estate jail for us, they can't. And then section C, we've got expiration date because, of course, this cannot not have an expiration date. All agency agreements must have an expiration date. And if they're for seller or buyer representation, they cannot have an automatic renewal clause.
Exactly.
Section 2 is property. Now, if this looks pretty familiar to you, it's probably because you've seen this basically exact same thing in the offer to purchase and contract. But still, we want to go over it with our seller. We want to make sure we've got the street address correct. We want to make sure that we have a legal description, and that means you should probably look it up. Where would we find that, Chris?
In the previous video, we talked about the idea of just going to your county websites. And oftentimes you'll be able to get a tax card. You'll be able to get a deed if necessary. I actually require all of my agents to pull this information and put it in compliance so we can matchy when we're checking them out.
Exactly. So you're going to look for plats. You're going to look for a PIN or PID. You want to look in your deed book and you'll have a page number. Whatever you need to do, just make sure that you're taking that extra step.
In regards to the legal descriptions, I always like to think that more is better than less. And also it's good information for you to go ahead and look up and find it and provide it for the buyer's agent. It makes it easier for them to write an offer on the property.
Exactly. All right. Our next section is section 3, the fixtures and exclusions. And even though this is not the contract, I think this is a perfect place for the agent, the listing agent, to have a conversation with the seller about what the buyer is going to expect.
Absolutely. When you're walking through the house, which the commission expects for you to lay eyes on these houses, they expect you to be walking. And while you're trying to figure out how to market the house and price the house, you should also try to determine if there are any things that will be controversial in regards to fixtures and have that conversation with the seller. Seller, if you're going to take it with you, are you going to take it down now so it's never seen? Or are we going to write it in the contract, or are you going to leave it with the buyer? Because what this contract says is if it's a fixture, it's going with the house if you do not do something different.
That's what Section A says, that fixtures are included in the purchase price, and those should be free of any liens, right?
Okay.
And then we know what fixtures are. Those are personal property, things that are personal property that have become part of the real property because you've affixed them to that real property. But there's other things that can also be a little bit, I don't want to say controversial, but people always have questions, or there's usually arguments about them. Or do I have to leave it? Do I not have to leave it? So that's why in Section B, we have specified items.
Yeah, pay attention to things like appliances. Pay attention to things like, I always like to mention garage door openers. That's one of the ones that oftentimes sellers don't think about, and they accidentally leave them in the car and take them with them. But according to this, they are defined as real property. Basketball goals. You don't want to end up having an argument about something so simple that could have been discussed up front.
Exactly. And I always like to point out that when it comes to plants, maybe because I have a favorite plant myself, it is in a movable container, so it would not be considered a fixture. But if that same plant was in the ground, I would have to leave it.
Great point.
All right. Well, if we're talking about leaving things, then we do need to talk about the fact that if you're leaving something that's considered part of the smart home, anything that's connected electronically to your digital footprint, you need to make sure as the seller that you unpair those devices, right? Because nobody needs to see your private, whatever it is that you're doing. Make sure that the seller knows, hey, by the time that we get to settlement and or closing, this needs to be disconnected and it's going to be in a state where the buyer can now hook up.
Yeah, and I'm actually old school, and I like to think I don't have very many of these, but I started counting one day, and I actually do. My heating system is actually tied to an app that I have on my phone, and we have a couple of appliances that we can run remotely. And if I have a few, then you know that this is very common in houses today.
It is true. All right. Our next section is going to be talking about items that are leased or not owned. This is a great time to talk to your seller about different things like antennas, satellite dishes and receivers. Are there any appliances, alarm and security systems, things that they may have installed in the home that they are paying for? They don't own them, they're just leasing them.
Yeah, sometimes the way that Kandyce just went over this, you might want to go with it because they may not think that they have any of these items. But when you go over it in paragraph form, it may, oh, yes, we have our alarm system is leased. And so it may help them come up with some of these items.
That always reminds me of a cable box. Like when we had cable boxes, you didn't own it, you just leased it.
Exactly.
Sometimes with, the thing that brings the internet in. What's it called?
I don't know. You took a modem?
The modem.
Okay.
Sometimes the modems are not owned by you. So that same thing. Walk through and have a conversation with your seller. Right? And while you're having that conversation, this is where you're going to come to an agreement with the seller about the things they want to keep. Something that's going to be considered a fixture or in that list that they want to keep. And if it's something they do not want to convey, we're going to put it down here. Not because this is the contract between the buyer and the seller, but just so that you can be on the same page with your seller client and make sure just avoidable mistakes don't happen.
Yeah, for the most part, you're going to advise the seller at this point, well, look, if you're not going to convey it, let's go ahead and take it down. But a very, very common example of this is TVs and TV mounts and things like that. If the seller took them down, it would affect the way they lived in the house. So they might push back on some of these items. So you give your best advice. If they don't follow it, you make sure it shows up in the contract the way that they want it.
Exactly. And I always think it's good to remind them that if the seller is removing something, they have to fix any damage.
Yep.
Now, if we're talking about fixtures, then we cannot ignore personal property. And personal property is not part of this contract unless we add it. What kind of items would we usually be seeing people leaving?
By far the most common is going to be the refrigerator, maybe the washer, dryer items such as that. And Kandyce, I'll say this, and I probably shouldn't, but because we're looking at the listing agreement right now, this is important because it does give you an idea of what they would like to convey with the property. Maybe it gives you a bargaining chip. But if you mess up here, it's not quite as bad as if you mess up in the offer to purchase. You understand what I'm saying?
Yeah, and I think that is something everybody should understand. Just because you, as the agent and the seller, have put something in this personal property section, if it does not make it to the offer to purchasing contract,
right,
you're just kind of screwed. All right, our next section is going to be about the home warranty. Have a conversation with your seller about whether they are or not willing to pay for a home warranty.
Yeah, and also use your vendors for this. They can do a better job of describing the home warranty. There's some amazing products out there, and if you try to memorize all of them, it would be difficult. But what Kandyce said is correct. It's the conversation right here that's important. Is this something that we throw in good faith, maybe, or from a bargaining standpoint with the to the buyer?
Agreed. So section 6, probably maybe one of the most important sections here, huh?
Yes, it's starting to get serious because all contracts must have the terms spelled out. There's nothing more important than the list price.
And this is what you're going to put in here. This is where I should say you're going to put the price that you're going to put this house on the market for. House, condo, townhome, whatever it may be.
Real quickly, not only are you going to tell how much you want, but go ahead, Kandyce, to the next part and we tell how we will be willing to accept it. A lot of agents kind of skirt over that, but that's actually important. Obviously, cash. I mean, everybody's going to take cash. But notice those next two, FHA and VA. There are some properties that don't qualify for FHA and VA financing.
Or maybe somebody doesn't want to take the time for FHA or VA.
Maybe they don't even consider it. So be careful and don't assume that your seller can or will accept all of these types. We had a case recently where we said that a condo was qualified for FHA, goes under contract, and it's not qualified for FHA. Mm-hmm. We have a misrepresentation on our hands. So when we talk about this paragraph right here, there's more to it than just the price. These are all important terms.
In Section 7 is our firm's compensation. Now, I know I said that Section 6 was important, but Section 7 is how we get paid. So would you say that's pretty important?
Yeah, and be very, very careful here. Notice that the first part, it's very common for people to be paid a percentage of gross sales price. If you're not familiar with it, that's very common in this area. I will tell you this, though. It's also common in our area for the listing agent to be paid and to then split their commission and give part of it to a buyer's agent. Well, what it's asking for here is how much total I expect from the seller. So if I expect 6% from the seller and I'm going to give away half of that or 3% to the buyer's agent, don't screw up and put 3% here, because if you do and the seller pays you 3% and you've promised that you're going to give the buyer 3%,
you did your job for free.
Made nothing. So this is very important, not only contractually, but also for your business.
Yeah. This is the total fee that the seller is willing to pay, whether it's going to be a flat fee or if it's going to be a percentage. This is the total. Now, we'll get to another paragraph that will show how you're going to split up this total commission, but this is the total. I don't think we can say total anymore, can we?
Nope. I think we're done. Use your quota.
All right. Now, under that section, if Section A is the fee, Section B talks about, well, when do we get paid? Like, when have we earned this commission? And if there's only one line you're going to remember in this entire contract, it is this Section 7B1 or I don't know how you say it. If a ready, willing, and able buyer is procured by a firm, a cooperating real estate firm, the seller, or anyone else during the term of this agreement at the price and on the terms set forth herein, or at any price or upon any terms acceptable to the seller. It's a pretty long sentence, but the importance of that sentence is so big. I mean, why don't you talk, Chris, about the exclusive right to sell versus exclusive agency and why this is just everything?
Yeah, there's literally so much in that sentence right there. For those of you who are preparing for the test, let me point this out to you to start with. Notice that there's a difference between when a fee is earned and when you are actually paid. Oftentimes, and Kandyce jumped down to that. So oftentimes you've earned your compensation way before you get paid, because what it describes in that sentence right there is two conditions. Either you bring a ready, willing, and able buyer at the terms of the contract, which means full price, full terms, or the seller accepts lesser terms. So what we've just identified is what you have to do to earn your fee. But then it goes a step farther, and it says that under the exclusive right to sell, it doesn't matter if you procured the buyer, another agent procured the buyer, or his next door neighbor came over, because it doesn't matter where the buyer comes from. Under an exclusive right to sell listing agreement, you will have earned your compensation. Now, where Kandyce was going with her comment was, just real quickly, if you're preparing for the test, please compare the exclusive right to sell, which we're talking about right now, to an exclusive agency listing. And under the exclusive agency listing, you're the only agent that will list the property, but the seller could compete against you as a for sale by owner and not owe you anything if he sells it himself. And then thirdly, for test purposes only, we don't do this in our area, but an open listing agreement just simply means any agent who has a contract can list that property, and they will only be paid if they procure the buyer. Only the agent who procures the buyer will get paid. Open listing versus exclusive agency versus exclusive right to sell. Study that for your exam. And exclusive right to sell is by far the most common because of the protections it has for the agent and for the seller.
I do believe you just went over a number of potential test questions, because that understanding about the fact that it's either exclusive or exclusive right to sell are open. And then, of course, you get paid if a ready, willing, and able buyer is found by anybody. I don't care if it's aliens coming down from out of the sky. You have earned your commission. And we do have that little protection period in here. That protection period is saying, look, if I procured a buyer, but they don't decide to buy a house or buy your home until after this is over, and you're going to choose how many days. If they decide to buy the house after this listing is over, you still owe me a commission, seller.
But only for the buyers I procured during the time that I had the listing. If it's a brand new buyer, no.
Exactly. And it's also good to point out that if another firm lists after you, you also won't get paid.
Yeah, you waive your right to your buyers at that point. But you can be a buyer's agent if somebody else listed it.
That's true. So our next section is when we're going to actually get paid. And I like to say that you get paid when the people get their keys, which is not going to be until after closing, which if you watched our offer to purchase and contract video, you know closing is settlement plus recordation of the deed. Now, I think we're going to go ahead and jump on down to this next paragraph here, additional compensation.
Can I make one more point before we go?
You sure can.
It was running around my mind. I was trying to think about how to say it. And let me go back and remind you of the language that we talked about, the ready, willing, and able buyer concept. For test purposes, keep this in mind as well. If a seller has an offer that is full term and they turn it down, we can't require the seller to sell the house, but it doesn't change the fact that we may have earned our commission, even though the house doesn't sell. Extraordinarily rare in the field, not rare.
But they do like to test on that.
They do like to test on it.
Yeah. As always, he's correct. So we're going to jump down to the additional compensation section, which is basically saying, look, if you are going to receive any additional compensation as the agent, the seller is agreeing to it, right? They're going to permit the firm to have it, but you do need to tell them about it. The firm is going to have to tell you about this idea they may be receiving some extra monies.
Yeah, a little bit rare that this is activated on the seller side, but we'll talk about it again in the buyer agency agreement where it comes up a lot.
So Section 8 is the cooperation with and compensation to other firms. Now, you all remember that Chris brought up, this is a total commission that we talked about at the beginning of Section 7. See where it's circled there? Right there. Well, Section 8 is telling us how do we split this up. So if, let's say a firm is getting, can we be generous and give the firm 10% today?
Sure.
Hey,
give my firm 10%. Yeah.
If you're going to go for something, go big. So we're going to go for 10%. And what I would do if I was the listing agent is I would have put 10% as the total amount in Section 7. And then in Section 8, I'm saying, what percentage of that would I be willing, or amount, would I be willing to give a sub-agent that's representing the seller? And what amount would I be willing to give a buyer agent that's representing the buyer? And then in some cases, some firms have a different compensation plan and a policy. That is really, really rare, but that is an option.
Mm-hmm. Yeah, and this, rather than go into a whole lot of detail about this, you'll get more in the field, but it literally tells the seller what you're doing with the money. Why? Because he's your client. He deserves to know what percentage of it you're paying out to another party and how they will be represented.
Exactly. So Section 9 is the firm's duties, and this is going to be spelling out to you and the client what your job is. What is it that you're responsible for doing? Because it's more than just putting a sign in the yard. You are saying that you're going to use your best efforts to find a buyer. So that means you're going to have to find, a sign to put in the yard. You're going to put it in the MLS. Now, all of those are subject to the seller agreeing, but you can't just take the listing agreement and then throw it in a corner and do nothing with it.
Yeah, on this whole paragraph, I like to go over it just real quickly. First of all, I think it's a read through. We could explain it, but it's a pretty easy read through. But it does help the seller to understand. But I'll give you one example in here. We never actually say that we're going to sell the seller's house. our duty is to use our best efforts to find buyers. We can't actually sell the seller's house. It's not our house. Only the seller can sell it. So as we're going through here, it's kind of talking about what we're going to do so that the seller understands what we're doing for our compensation.
Exactly. Now, I love the fact that this now tells the seller, look, I cannot share the price or other terms of an offer, not without their permission. So I think that's important for the sellers to know. And the seller needs to be reminded that we as agents have a legal responsibility to disclose material facts.
Yeah, in this combined paragraph here, the two potential test questions. One of them is, if we get a multiple offer situation, I cannot disclose the terms of those competing offers. I couldn't do that by law, even if the seller gave me permission, but the seller could give me permission to let someone know that there are multiple offers. So throughout here, we're kind of defining not only what we're due for the seller, but how we are actually bracketed by rule and law.
Mm-hmm. Now, earlier today, you had talked about that form that agents can use to confirm that they told sellers and or buyers that there's different inspections that can happen. But I like to talk about this form. What's that form called again?
Professional Services Disclosure.
The Professional Services and Disclosure. I also like to point out that when you have other services, if that seller is going to say, hey, I want to get an inspection before we put it on the market. We want to have it appraised before we put it on the market. The seller is agreeing to pay the full amount for those services directly.
Yeah, be careful, agents. Don't get in a position where you order a test that the seller has not agreed to pay for. Otherwise, it could come out of your pocket.
And nobody wants to do that. All right. Now, this big section right here, what is this talking about, Chris?
Well, interestingly enough, I mentioned earlier that there are rules of agency agreements. And one of the rules of agency agreements is there must be standard non-discrimination language. And if you want to have a pro tip on this, notice that it's in all caps and it is bold printed. Anytime that you see something like that, it doesn't make it more important. It's very important, by the way, but it doesn't make it more important than anything else. It just means there's a corollary rule that says it should be drafted in such a way that it draws attention to itself. That paragraph clearly draws attention to itself. And listen, if your sellers are not going to agree with you to follow the fair housing laws, then you need to remind them this is not only going to be a penalty to you as an agent, these are actually state and federal laws. It would be binding upon the sellers themselves as well.
Mm-hmm. And along those same lines, that's why we have this warning about buyer's letters to sellers. Now, sometimes, and I will say in different states they still do this, when a buyer wants to kind of get an edge up on other buyers, they'll write a letter to a seller explaining why the seller should choose their offer. However, you'll see in this warning that this could be something that violates your state and federal fair housing laws. I'm not saying off the top that they're all illegal. We're just giving you a warning that you may want to reconsider or talk to an attorney before you decide to turn in a buyer's letter or accept a buyer's letter from a seller.
Yeah,
from a buyer, excuse me.
And the buyers and sellers don't understand this, but Kandyce, I had to deal with one earlier this year that showed, and you tell me how many classes are offended in this particular case. It was a family. It was a husband and husband, actually, and they had a child in a wheelchair standing in front of the Christmas tree. Now, all of this...
Did they hit everything all in one?
Yes. I looked at them and I said, man, they are great. They're a lovely couple, a lovely family. But I know of at least 3 potential classes that if we had passed that on, that they could have been in violation of. And they didn't mean it. They just didn't know.
Exactly. So make sure, we talk about a lot of things in these courses, but fair housing, that is something, not that you shouldn't take everything seriously. That is definitely something you do not want to get in trouble for or even get questioned about. So make sure you're staying on the right side of that. Okay, think we can move on to marketing?
Yeah, and this one, unfortunately, we have to get really, really boring on marketing because this says some very, very specific things here. Notice to start with, it says commencement of marketing. Now, when you look at that, understand that there might be a difference from the effective date when you took the listing to when you start marketing the property. Maybe the seller is going to fix some things up. Maybe you took the listing, but he's still under an agreement with someone else and it hasn't started yet, okay? So the commencement of marketing could be different than your effective date. Once we decide what's going to happen with the marketing, notice that it gives us an option here. Is this going to be publicly marketed? Listen, not only is this by far the most common, but this is also the preference of the Real Estate Commission as well. Because what's going on with public marketing is you're exposing it to as large a market as possible. And that's what the commission believes that agents should do as fiduciaries of the seller. Scroll down a little bit, Kandyce, and let me go ahead and take this into consideration. Under the public marketing, almost everything that you do for your seller, you have to have permission for. Putting a sign in the yard, doing open houses. So all of that is considered under public marketing. But as you go down just a little bit farther, the other option is this could be office exclusive. So understand we're still in one paragraph. Marketing is going to start, and it's going to be either public, which is by far the most common, or it's going to be an office exclusive. Because of past concerns with what were called pocket listings, the commission does not love the office exclusive idea. However, they recognize that sellers may choose it. So let me finally get down to what I think the crux of this is. If you are going to recommend to your client, or if your client is going to choose office exclusive, they need to understand that they are not going to be marketed to the broadest possible market. And then if you play off of that comment for just a moment, you'll figure out very quickly that typically what brings the highest offer is being exposed to the largest market. So Kandyce, I apologize for getting deep into this, but this is actually very, very important for the sellers to understand how the property is going to be marketed. You should explain it to them, and then they choose how they want to be marketed. Do not force an office exclusive onto a seller who doesn't have an understanding of what they're getting into.
Don't think I could have said that better. The seller needs to choose. Is this going to be public marketing, or is it going to be office exclusive? And they're going to need to initial which one they want. And of course, again, like you mentioned, we go over what it is they can expect. Will there be open houses? Will there be signs in the yard? Don't forget, sometimes some HOAs don't allow for sale signs. Is the person willing to have a lockbox? And helps if I don't cross it out, but are they willing to have a lockbox? Not every HOA is going to allow lockboxes, and not every seller wants to have a lockbox on their door or any place on their property.
Yeah, just a quick pro tip, not testable. If someone does not allow a lockbox on their property and they literally want you to be available for every showing, that is a difficult way to sell a property because, again, it's hard to get full exposure on that. So be careful if someone says that they do not want to allow this access. Remember, you do not have to take every property that's offered to you. Take the ones that meet with your business model.
Exactly. Now, you said a word, exposure. And I think it's important that you always talk about with the seller that because there comes exposure, there also comes the risk of somebody using the lockbox incorrectly, or the visitors may start going through some of your stuff, or, basically we don't have control over exactly what is said and who does what. And they need to be aware of that. So they should make sure they move any cash, jewelry, firearms, anything like that. Medications, anything they don't want other people to have access to, that needs to be put away safe.
Yeah, absolutely on this. In this paragraph, now keep in mind, I don't remember what page we're on in the paragraph, but sometimes when agents get deep into these paragraphs, you've passed the important parts. You passed the listing price. You passed the commission. Honestly, that's really what the sellers want to know, but there's so much information in these later pages that you need to go over to help them understand.
Now we have another warning here, and when there's a warning and it's in red, it's big. Remember, it could be a crime under federal and state law to listen to or record an oral communication through the use of any electronic, mechanical, or other device without the consent of a party to that communication.
Yeah, pro tip on this, what it's telling you is it's illegal to record someone's voice, but here comes your pro tip. You should assume, agents, and you should tell your buyers that when they're in that house, they are probably being recorded on video. And I promise you their voice is being recorded as well. And people say, come on, they can't do that. That's against the law. No one's ever going to know but the seller. But I have had too many times where a counter offer was given based on terms that we had literally mentioned while we were in the house. So I know they had to have been eavesdropping on those.
And you know Alexa is always listening.
Yep. So it's Ring doorbell.
All right, earnest money now. Earnest money is always so important to talk about, especially when we do deal with the offer to purchase and contract. But being in the listing agreement, this is where we want to point out to the seller, look, is our firm willing to hold the earnest monies or the trust monies, or do we want it to go to an attorney instead? It also points out that just in case there is a default and somebody doesn't agree who's going to get the money, that money is going to stay in the trust account until an agreement is reached.
Yeah, there used to be a couple of test questions on this, but I don't know if they test it anymore. The assumption used to be that it was in the listing firm's trust account, but it's not as common as what it used to be. But there used to be a question predicated on that. I don't know that there is. Another interesting concept on here is if, in fact, the buyer breaches and they forfeit their earnest money, according to this paragraph right here, the listing firm is actually entitled to half of that money. So there's a lot of interesting stuff in here. I'm not sure how testable it would be.
Yeah, I think it's one of those interesting to know, but who's going to actually go through and enforce it? All right, we're going to keep moving, and you'll notice if you've watched the OTP video, which, by the way, we didn't go into a lot of detail on the earnest money here, but we definitely did on that video, so you can look. I'll link it up in the video as well, but we need to talk about seller representations. And this section is another section that's almost identical to what you will see in the offer to purchase and contract. These are questions that the seller is going to have to answer or confirm that they've been answered correctly on the offer to purchase and contract. So why not have this discussion now?
Yeah, this is actually probably more important now than it is in the offer to purchase because you're getting the information from the person who should know, that being the seller.
And so you'll ask them about how long they've owned it. Are they going through bankruptcy? Is this going to have a manufactured or mobile home on it? Can we know about the owners association? And I know a lot of agents like to skip over this, but I love the fact that it asks to make sure that the seller has gotten a copy of the offer to purchase and contract so that they can review it before an offer comes in.
Yep.
And there's this professional services disclosure and election form, that form that says, hey, seller, these are some of the inspections you can have, but if they're ordered, you need to pay for them. Yeah,
we're going to be asking the sellers to sign these forms, and things will be moving quickly at that time. It's nice if they can review them ahead of time.
Of course, we want to know if the seller is in a flood hazard area. Regardless of what the seller tells you, it is still your job as a North Carolina broker to pull up the FEMA maps. You're going to ask about synthetic stucco because we know in North Carolina the presence of synthetic stucco, or if there's ever been a presence of synthetic stucco on a home, that is a material fact that you must share. And you're going to ask about, do they have termite bond, or are they having somebody come out and look and treat for termites, or, make sure that we don't have any termite activity. You want to ask about the current liens so that you can see, is this person going to actually be able to sell and make a net? You want to make sure this is not going to be a short sale where they're going to end up having to come up with some money or make some type of arrangements with the bank because the money that's coming in from the purchase price is not enough to cover their debts.
Yeah, and more commonly right now, we don't have as many people that are upside down short sales as we've had at some points in the past. But even having said that, the seller is clearly going to want to know how much money they're going to net. They're probably going to use that money to buy a new house. And so it helps to be very diligent about this. You're never going to be to the penny on this, but you should be diligent. I would consider it material information if the seller will share that information with you.
Exactly. If the property is leased, then, have that conversation. Sometimes they say, I have a second home, and they don't say there's an actual tenant in there. So you want to just get more information. And then section L is talking about the FHA appraisal. Why is that important, Chris?
FHA appraisals now stick to a home, and I may be wrong about this. You can talk to your lender, but I believe it's 4 months. So in other words, it does say 4 months now. So what will happen is if an FHA buyer has gone under contract, the house didn't appraise and it falls through, there's no reason to try to sell it to another FHA buyer for higher than that number for the next 4 months.
Mm-hmm. The next section is special assessments, which we talked about in the offer to purchase and contract video, which should be your hint that you probably want to watch that too. But here's where you're going to talk to the seller to find out, are there any special assessments that you need to be aware of as the agent, that the buyer and the buyer's agent needs to be aware of, so that we can share those and make sure that we are taking those amounts in consideration when we're looking at the seller to net or the seller net form or anything else.
Yeah, so important from one way or the other. The seller is certainly going to want to know how it affects his net, if any. And then if it's a proposed assessment, it's a material fact which has to be disclosed to the buyer. So special assessments, they take up very little space in the contract, but they're extraordinarily important.
Yeah, they can make a huge dent into the happiness and the smoothness of a transaction. Mm-hmm. Section N is talking about the fuel tank, and you want to ask, especially on larger properties, you may not have seen the fuel tank, or maybe it's buried. Either way, have a good conversation about if there's a tank, do they own it? Where is it located? What type of fuel do we have in it? How often does it get refilled? And who is it that's doing it? These are all questions that you want to ask. I know, just another pro tip, sometimes some agents will ask the seller for their utility bills from previous months just to give that information and have it ready for potential buyers.
Yeah, this comes in handy for knowing your area as well. The commission has been really diligent in the last 2 update classes to talk about if you sell outside of an area that you really know, that you need to be familiar with the material facts. To give you an example, for those of you who are familiar with Durham, there's a spot that's been redeveloped down on 9th Street. And a lot of people wouldn't think about the fact that in years past, they had underground storage tanks. So if you don't know to look for it, you might miss that, and that could be very costly to your clients.
Mm-hmm. Now, of course, we've got duties as agents, but in this contract, we need the seller to promise to do some things, right? They're going to need to give us that RPODS, or the Residential Property and Owners Association Disclosure Statement. They're going to need to give us that MOG, M-O-G, the Mineral and Oil and Gas Rights Mandatory Disclosure Statement. And if the house was built before 1978, they need to give us the lead-based paint or lead-based paint hazard addendum.
Correct. Yeah, the fact is that they have duties that they have to do. We can't fill those forms out.
No,
they
never.
fill those forms out. And so that's part of their duties. And they could have repercussions in regards to the first 2 disclosure statements there. If the seller doesn't fill them out, the buyer may end up having a right of rescission on that property.
Exactly. Now, I'm going to jump down because there's a lot of legalese there, but I'm going to jump down to E here, where we're going to say that the seller is agreeing to execute and deliver at settlement a general warranty deed conveying fee simple, marketable title to the property, including legal access to a public right-of-way, free of all encumbrances except ad valorem taxes for the current year, utility easements, rights-of-way, and unviolated restrictive covenants.
Yeah, as we mentioned a little bit earlier, this would be a case of if the seller cannot do that, do one of his duties, even after going under contract. Remember, we earn our compensation for bringing a buyer. If the seller can't deliver title, they're in breach. They're going to owe not only the buyer some money, but they're possibly going to owe their agent some money as well.
Mm-hmm. All right. I will point out very quickly that if this is going to be a short sale, meaning the seller is not going to have enough money to cover all of their debts that need to be covered, you need to make sure that you have an addendum to this agreement. A lot of banks will already have one, but it's something to keep in the back of your mind. As we move forward, we've got home inspections. And of course, I always do. I like to ask a seller to get a home inspection so that they won't get any nasty, huge, costly surprises when the buyer says, hey, this is what's going on. Would you be willing to fix it? So have a discussion with your seller whether they would or would not be willing to get a home inspection.
Yeah, from a materiality standpoint, some sellers may resist this. But having said that, as an agent, I'm certainly going to suggest it. And listen, it's not all about taking liability off my shoulders, but a home inspector is clearly going to see things that I might not pick up as a novice inside a house.
Mm-hmm. Our next section is photographs and other materials. This means you need to have a conversation with your seller about who's paying for the pictures, who's going to have access to them, the fact that you have the right to see it. Just it's a good conversation to have because most of the time nothing big happens, but when something does happen, it can get very ugly very quickly. Now, additional terms and conditions, how do you feel about that section, Chris?
If there's something you absolutely have to write in there, by all means, you have a spot for it. But obviously, you'll hear us say this many times. We try to avoid having agents draft things into these contracts that are unnecessary. So my first comment would be to avoid it. Having said that, I have seen cases before where I'm getting ready to sell my property and Mr. Smith down the road is interested in buying the property. So I go to an agent and I say, hey, list my property. However, Mr. Smith, if I sell it to him, I don't think I should have to pay you. So I've seen an agent come in here and write something to the effect of exempt Mr. Smith or something to that effect. But by the way, if you're going to do that, do it only for a very limited term. I'd hate for Mr. Smith to come 6 months later after you've spent all your money marketing it. Yes. So again, this is kind of a rarity. I don't like agents using it a whole lot. Can you think of anything that you've seen them use it for practically?
No, that's pretty much all I've seen it for. And, quite honestly, I would tell you to talk to your BIC before you do anything and definitely just have a conversation with the attorney because you want to make sure you word that correctly.
Yeah, avoid it if possible.
Now, my favorite section, this is going to be talking about dual agency. This is section 17. And just as a reminder, we said that this contract way at the beginning was an exclusive right to sell. Just everything up until this moment has been making it so that the sellers and the firm have an exclusive relationship. However, sometimes there is a buyer who wants the seller's house, and that buyer is also represented by the same firm. Now, I know we're all aware that in order to have dual agency, where the firm is representing both the buyer and the seller, we are going to need written confirmation and permission. Having said that, this section is designed for you to explain how dual agency works. And then as we go on to the next page, we're going to see where the seller is going to give authorization or limit whether or not they're going to have dual agency or if they only want exclusive representation. So Chris, tell us how it works.
Okay, go back to the top real quick. Okay, just as kind of a FYI on this, some things in this contract are written better than others. If you ever want to understand dual agency, read this paragraph in detail. This is one of the paragraphs I think the attorneys did an amazing job where they talk about what dual agency is and how it arises and what's going to happen to confidential information. Kandyce, do you want to go into detail on that, or do you want to just leave it with the idea of let them read it and help them understand?
I think we should go ahead and we'll not do it now, but maybe we can do another video just on agency.
Okay.
Leave us a comment down below in the comments if you'd like us to do agency, because I think we can if people want it.
Yeah. It addresses how to disclose information and what to disclose. It talks about the firm's role as a dual agent. And to be quite honest with you, unless dual agency arises, I'm just your exclusive agent, just like always. So it goes into details about that and what the seller's role. When we get to the buyer's agency agreement, it just simply says buyer's role there. So if you learn it once, you're good on these forms. Now, let's talk about what's happened in this contract that actually makes a whole lot of sense. Okay, now we have to get our sellers to either agree or not agree to dual agency. So, Kandyce, my firm has 180 agents currently. Do you think most of my sellers should, in fact, consider dual agency?
Yes.
Okay, they should consider dual agency because if they don't, none of my agents are going to be able to show the property. Okay, in the seller's mind, though, they might be thinking, how can you be fair to me and be fair to the other party? That is a completely legitimate question. So we're going to work through dual agency here and say, listen, Mr. Seller, I need you to initial the part that says dual agency, because if any of my agents show my listing, we're going to be in a dual agency situation. But notice in the sentence just below that, it says, seller does or does not authorize the same individual agent to represent both the seller and the buyer in a transaction.
There you go, right here.
Yeah.
I didn't mean to cross it out.
That's okay. That's okay. To me, that's what most sellers are saying. They don't want Chris to be representing both them and the buyer because they're worried that I can be fair to both parties. And in fairness to the seller, that's true. How can you serve two people simultaneously who have competing interests? Okay, so now they've told me they don't want me to do that. Now, those of you who are in class are studying designated agency, and what designated agency allows is, even though we are in a dual agency situation, designated agency allows for one party to be designated for the buyer and a separate party to be designated for the seller. So notice here that if they choose designated agency, technically they're going to get the same menu of services that they would get if I was an exclusive agent. And then this may not be meaningful to you, but it's an extraordinarily important point. Kandyce, following the sentence right there where you just stopped, start highlighting that. In addition to authorizing firm to act as a dual agent, seller authorizes and directs the firm to designate an individual agent. So what I wanted to point out to you why that is so important is that seller is saying, hey, look, Chris, this whole dual agency thing, I'm not feeling it. Okay. And even if you had another agent in your firm who had to be both, who had to represent both the buyer and me, I'm not feeling that either. But you know what? If you had a situation where you, Chris, could represent me and a separate person, Kandyce, in the firm could represent the buyer, I would be okay with that because that gives them the separation that they would get through exclusive agency. And if that is the case, which it will be, trust me, if they're okay with dual agency, they will love designated agency and get them to initial that indented portion there as well. And then finally, you look at the third option, exclusive representation. Now keep in mind, under exclusive representation, it would be extraordinarily rare for someone to list with my firm with 180 agents and then say, oh, but by the way, none of your agents can show the property. If you think about it, if a seller goes to a large firm because they want exposure, it would be almost contradictory to ask for exclusive representation whereby none of those agents could show the property. This is a very workable way, and you need to study this in class. And at your company, you need to know what your policy is and talk with your BIC if you don't understand it.
That was a lot.
That was a lot.
But it is so very important. So I'm going to Kandyce it and break it down to its bare bones. And that is not because what Chris said is not important. It is. I just want to make sure you all understand it. When you get down to this section of the contract, and this is going to be the same in the buyer agency as it is here, what you're getting your client to say is, look, we're signing this contract, and in general, I will be your exclusive representative. But there could be a buyer who is also working with our firm that wants to see this property. In order for that to happen, you would have to authorize dual agency. And that is where, if they're okay with dual agency, they're going to check here. Now, yes, there are types of dual agency, as Chris explained. Once they choose dual agency, they can choose whether or not they want designated dual agency.
They will initial there, not check.
Oh, did I check? Sorry. I said check. Sorry. They'll initial there. He's absolutely right. Or this seller could say, you know what? I want you and your firm to always, always, always represent just me. Like Chris said, I think that's kind of weird sometimes, but there are definitely firms that don't offer dual agency at any type. And that works as well. It's not what we want. It's what the client wants. So if they want to make sure the entire firm is only team seller, that's why we have this or here. This is where they would initial, I want exclusive representation. And that means nobody else at the firm can be a representative of a buyer. In fact, you can't even show, nobody at the firm can show the house with that checked, or I should say initialed.
I only point that out because now when they're working with real estate agents disclosure,
yes,
it is a check instead of an initial. So.
I know, they just need to keep it to one, but that's okay. All right, so I would hate to talk about it, but we got to talk about termination. You realize that this is going to continue on until the end, and I mean, there are times where sometimes the seller doesn't want to work with you, you don't want to work with the seller. This is where you definitely need to talk to your BIC and call an attorney. Right? So there's going to be all sorts of things discussed here. What happens if somebody breaches? You've seen this language in other contracts. People will need to, go through mediation before we start suing each other. And let's talk about who's paying the attorney fees. But most definitely this section, talk to your BIC about it and understand it.
Just real quickly to turn it into a test question, if you're in pre-license class, there's this old test question that still hangs around. It talks about the idea of, does a seller have a legal right to terminate the exclusive listing agreement? And your inclination is to think, well, yeah, I mean, it's a right to work state. Yeah, they have a right to terminate. But keep in mind, the question was, do they have a legal right? Seller can terminate if they want to, but they will be in breach if they do that. So technically speaking, they don't have a legal unilateral right to terminate.
Look at you using those big words.
Yeah.
Yeah. Section 19 is going to be our wire fraud warning, which you'll see basically in a lot of our contracts, just reminding people that wire fraud is still a big thing. And unless somebody's trying to lose large sums of money, they want to be very, very careful. Right, and I think that's pretty much it. We're going to go in and we're basically saying this is the entire agreement. And if there's changes, they need to be in writing. And if there's anything we want to agree on, it needs to be in writing. Yes?
Yes.
And then everybody's going to sign. Although I do want to point out that you should tell your seller that there's a series of Q&A brochures that will maybe answer some questions. Even though you're there to answer them now, they might come up later. So think about that. Maybe you even want to supply those.
Yeah, there are some sellers out there who will want to do their research on kind of the way it works. These are great brochures. They are written by the commission. So therefore, by definition, they are correct.
And they are free.
Yes.
We like free. So here is where you have the seller sign and get their information. If it's an entity like a corporation, an LLC, a trust, something like that, we've got the signature there. And then you, as the agent, are going to sign on behalf of your firm.
Yeah, a couple of things there. First of all, Kandyce mentioned this a little bit earlier, and we've said it multiple times. But the fact of the matter is, every seller, please get their signature. And if they have a non-titled spouse, they need to sign as well. We actually have an extra form. If we need to, we can add names to this.
I think it's called additional signatures.
Additional signatures addendum if we actually need it. And then the last point from a testable standpoint, notice that Kandyce said you, the agent, you have the authority to sign for the firm. You're a general agent of the firm, and therefore you have the ability to sign. So don't fall for a test question that makes you believe that you need your broker in charge to sign this form. You have the authority to sign on behalf of the firm.
Exactly. Wow. I can't believe that's 13 pages, but there's so much good information. Anything else you want to add, Chris?
No, it is well written in sections. It's easy enough to understand. It has gotten longer, so it'll take a little while. But know this form and know more than just the first 3 pages, okay? Mm-hmm. I think the sellers deserve the opportunity to at least discuss what's in these provisions on these out pages.
As usual, you're correct. So I think I'm just going to say goodbye for now, and I guess we'll talk to them later.
We'll see you in the buyer agency agreement.
Y'all have a great one.
Bye-bye.